Hello viewers, I'm Major General Neeledra Kumar for the YouTube channel Lex Concilium Foundation for the playlist Going Strong. As you are aware, this is the playlist where we speak to eminent people above the age of 80. In conversation, I'm here with Mr. K.K. Venugopal. Apart from your library, your law office and chambers are rated amongst the best, sir. Now, give some insight as to why did you sort of give importance to this, that the chamber, law office, etc. should be professionally of a top class?
No, but it's been inherent in me.
Okay.
Not that I have specially worked for that.
Yes.
My great luck has been that I have been getting very talented, brilliant young lawyers who have joined my chambers. 40 of them at least are now practicing.
Yes.
Either have become cabinet ministers at the central government. Yes. Two of them are judges of the Supreme Court. One has retired, one is still sitting.
Yes.
And who is likely to become a Chief Justice.
PC was under you.
Yes, PC
sir.
was there.
Yes.
Rangarajan Kumaramangalam was there.
Yes.
But unfortunately, he passed away.
Sir.
And at least 7 or 8 senior advocates who are practicing now in the Supreme Court.
That's a matter
and a
of
very
great
large
honor.
number of young lawyers who are passed out from my office.
So it is the practical training, the clinical training that they got under your eminence.
I think they have been of tremendous assistance to me. Without them, I could not have really done the work that I have been doing in the courts.
That's very, very kind of you. Again, sir, shifting back to your father, the eminence that he exhibited, would you like to name one quality that you imbibed from your father?
One is, I think the one quality is, I believe, integrity.
Yes.
And he maintained the highest standards.
Okay.
He would never make a wrong statement in court.
Okay.
Knowingly. And when he cited a case, if he read a portion of it which was in his favor, if there was another portion against him, he would read that also.
Bring that out also.
He would read that also.
Sir.
And I remember when I set up a new office in Chennai, in Madras.
Yes.
He was very ill. And he passed away 10 days after that.
Yes.
He came in his car because I was next door.
Yes.
And he could not walk that distance.
Okay.
And he came in his car and gave me a letter.
Yes.
And in that letter he said one thing, that I hope, I have no doubt that this will be chambers of an upright lawyer. And that's what you said.
That was
I wanted you. Therefore, I've been trying my best to follow what he was doing. And I believe that if I have attained some success in the profession, it's only due to him.
The sterling quality and the background that you got because of his work, sir. I would, from that time now, come to 2025. It is said that you have been a believer that because of the large volume of work that is now inundating the Supreme Court. So one option that you are known to suggest is that it should be bifurcated into the Constitutional Court as well as the Ultimate Court of Appeal. Now, would you like to elaborate?
See, what I find very sad is this. An apex court of a country, that is the Supreme Court of India, in the case of India, should handle cases of constitutional law, because it's a constitutional court.
Yes.
Or cases involving national issues.
Yes.
Or a dispute between two high courts, where there are contradictory judgments, and so on. But what is it that our present High Court the Supreme Court is doing? It is handling cases which only a High Court should handle. Rent control cases,
Yes.
matrimonial cases, land acquisition cases, and so on and so on. These are not cases to be dealt with by the apex court, bail petitions. All this should end at a lower level.
It was, the framers did not mean this, that such cases should travel to Supreme Court.
They never thought of that this would happen to the Supreme Court. And this happened only in the recent years, in the last 3 decades. And the result is they have 70 cases each. Now they have been increasing the number of judges from the original 6
Yes.
to now 32 or 34. And in spite of that, they are in arrears. Cases are pending, even criminal cases, for 8 years.
Yes.
Now imagine as to what is the fate of a accused if he is trying to get his freedom
Yes.
through the courts. The trial court takes 5-6 years, the High Court takes 8
Yes.
years, the Supreme Court takes 8 years, and if he is not able to give get bail or give the bail bond, then the result of that is he suffers, and finally is perhaps acquitted.
Yes.
And therefore, I think this is a great tragedy that the Supreme Court of India has tied itself with cases which only a High Court should deal with. Therefore, I suggested that very many countries have courts of appeal, and therefore, so far as India is concerned, they should have 4 courts of appeal in the 4 regions.
Okay.
Each court of appeal having 15 judges. Therefore, you are adding 60 judges of a very high quality, equivalent to the quality of Supreme Court judges, selected through the same process. Now, in which event they will absorb for their region, that is, it will be perhaps one in the Madras region, one in the Bombay region, one in the Calcutta region, and so on. They will absorb all these small cases, because perhaps the High Courts today make mistakes or
Yes.
are not absolutely transparent. Now, in which event you have to have a corrective machinery, and that will be the appellate court, will be the court of appeal, but of the same caliber as judges of the Supreme Court. And those judgments of the court of appeal will be final. There won't be an appeal to the Supreme Court.
Nothing beyond that.
Nothing
Yes.
beyond that. Therefore, and the Supreme Court will confine itself to constitutional issues of great importance, national issues of importance, or where there is a difference of opinion between 2 High Courts. Now, if this is so, the Supreme Court requires only 15 judges. They will sit in benches of 5 and deal with it. They will have a lot of leisure
Yes.
to read. Now they don't have time to,
Yes.
they sit up till 3 in the morning studying the 70 briefs which they have to handle the next morning. I mean, it's very unfair to the judges also. But unfortunately, they have themselves, over a period of time, converted themselves from a constitutional court to a mere court of appeal,
Yes.
High Court.
Sir, but with your long practice and having seen different governments, having been aware of different law ministers, this suggestion of yours, which is quite pragmatic and it makes sense, how do you think this can come about,
See,
rectify?
finally,
Yes.
at my instance, Article 32 petition was filed in the Supreme Court.
Yes.
Supreme Court has issued notice and said it will hear it finally,
Okay.
and has appointed me and someone else as some other lawyer as amicus
Okay.
to assist the court.
Sure.
And therefore, the Supreme Court will be dealing with this.
Maybe a meaningful step has already been
Yes,
taken in that regard.
There is no pending.
Yes, never pending, and it may come up. And with that, sir, coming to the NJAC, it is also known that you were in favor of the NJAC.
Yes.
Now, after the judgment and some years having passed, do you still hold that view?
See, it's not my view alone, that the collegium is not the best alternative
Yes.
for the selection of judges. The original constitution had said that it is a government of India which will appoint the president,
Yes.
will appoint the judges. Government of India and
Yes.
president are the same for this purpose.
Yes.
And they will do it in consultation with the Chief Justice of India. During the debate in Parliament, it was suggested, why not you have concurrence of the Chief Justice of India instead of consultation. But that was shot down by Ambedkar. He said, after all, he's a human being.
Yes.
And with all the weaknesses. Therefore, why should we give him the
Yes.
final veto, as it were? And therefore, in those circumstances, that was dropped, it was consultation. But what is it now? Through a process of judgments, one after the other,
Yes.
they were able to take over the entirety of the right to appoint judges.
Yes.
They turned Article 124
Yes.
on its head, and therefore instead of the government appointing in consultation, it became the judges appointing judges
Themselves. Yes.
themselves, and then for the government to say yes or no. It's come to that stage, and if they say no, there is a big hullabaloo, and therefore in those circumstances, the NJAC at least restored 124 to a modicum
Yes.
by asking the law minister to be a part of the NJAC. 3 judges of the
Yes.
Supreme Court, 1 law minister, 2 eminent persons.
Yes.
3:3. Therefore, the 3 judges would, of course, agree with each other, hopefully. And therefore, in those circumstances, one of the 2 eminent persons would accept, would go with them. But I suggested in my argument that there is something as reading down to render the provisions constitutional. Drop 1 eminent person, then it will be always 3:2. And therefore, the judges of the Supreme Court will always have their way in regard to the appointment of the judges of the superior judiciary.
Yes.
Unfortunately, they did not agree to do so, but the dissenting judge has condemned this. Justice Venugopal,
Yes.
who had retired,
Yes.
has exposed the manner in which the judges of the collegium decide on who should be appointed. I pat your back, you pat
Yes.
my back.
Quite right.
Therefore, this is a result. Justice Kurian, who agreed with the majority
Yes.
in upholding it,
Yes.
later said, I made a mistake.
Even Fali had said that having talking about first, second, third judges case, he says this is one case where my view prevailed, but I regret having.
He strongly supported
Yes.
the petitioners in that case, in the NJAC.
Yes. But
But what you said, we are regretting after the horses bolted. But unfortunately,
yes.
he believed that the judges would together be a great check on government and
Yes.
would always produce the best among the judges from all the high courts.
Yes.
But apparently even he felt
Yes. He felt that.
that he had made a mistake.
And any other, sir, like in Before the Memory Fades, the Fali in his book, he has spoken very eloquently about Justice Subba Rao. And he says that when he came, it was a watershed, definite turn. What are your views in that regard? Because you have practiced.
Subba Rao was a great judge,
Sir.
and very independent.
Yes.
And you would find in very many cases he was a dissenting judge.
Yes.
And his dissent, I would say, should have been the judgment in those cases.
Yes.
Therefore, he was a great judge, Subba Rao.
And if you were to speak about Justice Krishna Iyer, what would you say? Say, apart from giving apart his English.
I used to know Krishna Iyer very well. No, he is a brilliant judge and with a very large heart.
Yes.
And therefore, I remember I appeared for against against the scheduled castes
Yes.
in what is called the railway Soshit Dal case.
Yes.
And I was arguing against him. And he turned to me and said, Venugopal, you have to pay for 5,000 years of having oppressed the scheduled caste people. And I said, I was not there 5,000 years back.
Yes.
But what he meant was, that is my class of people
Yes.
who have oppressed them for years and centuries.
Yes.
And therefore we have to ensure that at least now they get their just deserts. And from that day I decided I will never appear against scheduled castes in any case, where benefits have been given to them. They deserve those
They
benefits.
deserve it. And thank you very much, sir. And the time that you have given, and
Yes,
I'm sure
correct.
that
It's
your
1 hour.
advice. Thank you very much.
Thank you.